This is a simulated asylum hearing of the United States Court of Appeals Ninth Circuit case Wilfredo Garay Reyes versus Loretta E. Lynch.
Today is January 14, 2010, file A094330-535, Asylum hearing of Wilfredo Garay Reyes. A notice to appear issued on March 25, 2009, alleging that Mr. Garay was unlawfully present and should be removed. Master calendar proceeding was on June 8, 2009. He conceded to removability as charged and the factual obligations through his undersigned counsel. Also on that date, Mr. Garay did not seek to designate a country for prospective removal. Today, I am designating El Salvador as a country for prospective removal in the event that the removal should be required based on asylee's admission and El Salvadorian citizenship. Based on the asylee's admission of the factual allegations contained in the notice to appear and the concession of removability, I find that removability has been established by clear, convincing, and unequivocal evidence. Before we begin, are there any preliminary matters we need to attend to?
Yes, Your Honor, there are.
Good morning, Your Honor. My name is Alma David. I'm here representing the asylee, Mr. Reyes. We are here today seeking asylum on account of a particular social group. We are also here seeking withholding of removal and CAT. We would like to enter several documents into evidence to begin with. The first one would be the Harvard Law article on gang violence in El Salvador.
Marked as Exhibit A.
Second, we would like to enter the USAID report describing a Salvadorian government program.
Marked as Exhibit B.
Third, we would like to enter the marriage certificate and birth certificates indicating that our client is the father of his U.S. citizen children.
Marked as Exhibit C.
And last, we would like to enter the psychologist report.
Marked as Exhibit D. Counsel, any objections?
No objections, Your Honor.
Thank you, Your Honor.
Good morning, Mr. Reyes. Can you please state your full name for the record?
Wilfredo Garay Reyes.
And when were you born?
I was born in 1984 in El Salvador. I am 26 years old.
Are you married?
Yes, I got married here.
Do you have any children?
I have two daughters. They were born in America.
What caused you to flee the United States?
I joined the gang Mara 18 and chose to leave the gang less than a year later.
When did you join the gang?
In 2002, I was 17.
And why did you join the gang?
I was looking for a way to improve my life. I was promised an easy life and more if I joined. A friend of mine introduced me to the gang.
This is the Mara 18 gang?
Yes.
What do you mean by improving your life?
My childhood was difficult. I was unemployed in the country of Guatemala and had to eat food out of the garbage just to survive. I did not see any other way out besides joining the gang.
And upon joining the gang, did you participate in any kind of illegal activity?
I robbed 3 to 5 wealthy ranchers for their money. They owned large tracts of land and cattle. The money was given to an orphanage and any remaining money was shared among the gang members.
Why the orphanage?
That is where the leader, Carlos, often visited. Carlos died about 4 months after I joined, and then the new leader was Francisco. That's when the gang became more violent.
You were saying that you left because the gang became more violent. What did you mean by that?
Well, when Francisco began to lead, the gang was committing robberies with guns. He threatened those who left, saying anyone to leave will be beaten or killed.
Were you involved with any of those robberies?
I was controlled by Francisco. I was given a gun and was the driver of 2 or 3 of the robberies, but I was never involved in any violent activity, not for Carlos or Francisco.
What makes you believe that you will be killed by Mara 18?
Well, after I decided to leave the gang, I went into hiding in another city about 3 hours away from my home, and it was either 1999 or maybe 2000. I saw Francisco driving in a vehicle with other people. That is when Francisco fired his gun at me. The bullet actually hit me in the leg.
When this bullet hit you in the leg, did you seek medical attention?
Yes, I received medical attention. I was released from the hospital the following day.
Was there any other incidents?
Months later, I was in a billiard playing pool when Mara 18 members with machetes attacked me. I tried to leave after defending myself, but there was 2 more people waiting for me downstairs.
And what happened next?
I defended myself by cutting off the hand of one of the members with my machete and shooting the other in the neck with my handgun. I then left in my vehicle.
Did you do anything else to remove yourself from the gang besides go into hiding?
In late 2000, I had my gang tattoo removed, so my tattoo is no longer visible.
When did you come to the United States?
In May 2001, I was 18 and I lived with my sister.
Have you been part of any gang or gang-related activity since you have been in the United States?
No, I do not want anything to do with gangs in El Salvador or in the United States. I have created a new life for myself.
Why do you fear returning to El Salvador?
I fear that the police will arrest me on being a former gang member and my criminal activity in El Salvador. I also fear that the gang will kill me.
Any other reason you fear being detained by the police if you're deported back to El Salvador?
Well, because almost all the time the people that are returned from here or they are deported from here, they stay in detention for investigation purposes.
Thank you, Your Honor. No further questions.
At this time, the DHS attorney will be asking you questions. If you do not understand the question, please let us know so we may clarify or reword the question. Do you understand? Attorney Ellsworth, you may proceed with your questioning.
Good morning. My name is Attorney Ellsworth, and I'm going to be asking you a couple questions. As you mentioned on direct, you came from the United States in May 2001, but you didn't apply for asylum until July 2009, correct?
Yes.
And you turned 21 in May of 2004, correct?
Yes.
And after you entered into the United States, you met with a lawyer prior to obtaining Mrs. David regarding your immigration issues, correct?
Yes, I did.
In your consult, your prior lawyer discussed and explained the options of filing a petition for asylum, correct?
Yes, but the lawyer did not tell me the importance of fighting for asylum. Instead, the lawyer had me file an application for temporary protected status.
In fact, your application for temporary protective status was fraudulent, correct?
Yes, but I trusted my lawyer at the time.
You're testifying that your prior lawyer did not tell you the importance about filing for asylum, and you had to file a fraudulent temporary protected status application. However, you did not take any actions against your prior attorney, correct?
No, I did not.
Was there any reason why you did not file your application within 1 year after turning the age of 21?
I was scared and did not know that I had to file asylum sooner.
You testified today under oath that when you were hospitalized after being shot in the leg, you were released the next day, correct?
Yes, I was released the next day.
And you attested and signed your application today in this court, indicating that the information in your application is true and correct.
Yes.
However, your written application indicates that you were in the hospital for 2 weeks and not 1 day. In fact, the psychologist report that was entered in as an exhibit indicated that you were hospitalized for 2 weeks as well.
Well, that is a mistake because I was only hospitalized for 1 day.
Okay, let's go back to the incident that you testified earlier regarding the being shot in the leg by the leader. You continued to live, after that incident occurred, you continued to live in the place where the actual incident occurred, in that general area, correct?
Yes.
On direct, you also testified about a second incident at a billiard in which you cut off the hand of one member, and you shot the other member with your handgun in the neck, correct?
Yes. I didn't have any other choice. It was life or death.
We can agree that those facts, the cutting off of the hand and the shooting the other member, are important for the court to know to clearly understand your circumstances, correct?
Yes, I agree would be important.
Yes, it would be important. However, you did not include these facts in your written application, correct? Would you like me to hand you your application to refresh your memory?
Yes, please.
Your Honor, may I approach? Thank you. Here's your application in which you signed and attested to today. After you're reviewing, please look up when you're done. Your Honor, may I approach the witness in order to pick up his application? Thank you. After you've been able to review your application, is there any reason why you did not include these facts in your application?
There must have been a misunderstanding.
No further questions, Your Honor. Thank you.
Your Honor, we would like to make a closing argument. Thank you. In lieu of removal, the respondent has applied for asylum, withholding a removal to El Salvador under CAT and relief pursuant to Article 3 of the Convention Against Torture. My client, who is a young 26-year-old, Wilfredo Garay Reyes, comes before this honorable immigration court seeking the protection of the United States. You have heard his credible testimony. It has been consistent, detailed, and specific throughout. Mr. Reyes has proven that he has experienced and will face persecution in El Salvador. He was repeatedly and viciously harassed, threatened with death, attacked, and shot. There is one reason why this misfortune befell upon him, and that reason is protected by U.S. asylum law. He was persecuted because of his membership in a particular social group, which is being a former member of the Mara 18 in El Salvador, who has renounced their gang membership. There is no doubt that Mr. Reyes was persecuted. As stated during Mr. Reyes' testimony, he sustained a significant injury from being shot in the leg and had to seek medical attention where he was hospitalized. Additionally, he was attacked by the Mara 18 members that were wielding machetes. Although he was able to escape narrowly, he still faces that if he is forced to return to El Salvador, attacks would continue and he would be killed. He fears for his life. The Board of Immigration Appeals has instructed the judge to evaluate the totality of circumstances when deciding asylum claims. In this case, all of the torture and particularly the shooting and attack combined compel the conclusion that Mr. Reyes suffered persecution. There is a compelling case to be made that he deserves asylum alone on this past persecution and irrespective of his individualized threat of the future persecution that he faces. Mr. Reyes has also met the burden of this future persecution if he was to be returned to El Salvador. Both for past persecution and future persecution, the four elements of a matter of acosta are satisfied. The alien must have a fear of persecution. Here, this is clearly shown by the attacks the Mata 18 members conducted after he renounced his membership. Second, the fear must be well-founded. Here, this is clearly shown by the previously mentioned attacks he endured. Third, the fear of persecution must be on account of one of the 5 protected grounds. Here, this is clearly shown by him being his membership in a particular social group defined as former members of Mata 18 in El Salvador who have renounced their gang membership. And last, the alien must be unable or unwilling to return to his country or the last country he resided in. Here, this is clearly shown by the testimony Mr. Reyes stated describing the persecution by the gang and his fear of persecution on account of his status as a former gang member, noting that El Salvador is a very small country and the gang would find out and kill him if he was returned. He also meets the burden on the past persecution that he experienced, including being shot in the leg and attacked by multiple Mata 18 members with machetes, showing that he faces more than a 50% risk of harm if he returns, meaning he is more likely than not going to face harm upon his return to El Salvador. And this is the burden he meets under withholding of removal. Therefore, he should be granted withholding of removal as well as asylum. If in the event the court does not grant asylum or withholding of removal, we also contend that he has met his burden of proof that he has experienced and faces torture in El Salvador, which merits protection against torture under the Article 3 of the Convention Against Torture, also known as CAT. He has evidenced his torture by the death threats made by the notorious Mata 18 gang. Again, we are asking of the court to grant asylum, withholding of removal in El Salvador under CAT, and relief pursuant to Article 3 of the Convention Against Torture. Thank you, Your Honor.
Your Honor, I would first like to address the asylum claim. I believe the asylum claim should be permitted and denied. The asylee is required to file asylum within 1 year of arriving into the United States, unless there is a change in circumstance or there's extraordinary circumstances, which is further explained in 8 CFR 1208.4. In this case, a change in circumstance could have been the fact that he was an unaccompanied minor. However, he arrived as a minor at the age of 18, and even as turning an adult at the age of 21, he's still not filed within the 1 year period. Extraordinary circumstances in this matter could have been ineffective assistance of counsel. The asylee testified today that he did not do anything in regards to taking any action against his prior counsel, and this he did not comply with any of the requirements set forth in 1208.4. When I inquired whether there was any other further reasons in regards to his asylum application on why he didn't file within the 1 year period, he indicated that he was scared at the time and didn't know the importance of filing asylum within that time frame. However, ignorance of the law and fear does not make the 1 year time frame waivable nor excusable. Thus, at this time, I believe that the asylum claim should be pretermitted and denied. In regards to his withholding of removal under the CAT, that should also be denied. In regards to his past persecution, the asylee in this case voluntarily joined this gang. He also continued to live near the place in which he was shot in the leg, as he's testified today. This shows that he did not feel threatened enough in order to try to relocate. The testimony did not meet the standard to stand alone. His testimony was very inconsistent. As we've pointed out on cross today, he had a period of hospitalization. He testified on the stand that it was within a 1 day he was released. In fact, in regards to the psychologist report, as well as his application, he indicated that he had a stay of 2 weeks. I find that to be a huge discrepancy. He also missed a lot of facts in which he should have concluded that he stated on the stand, but not in his application. He indicated that he cut off the hand of one of the members and that he shot the other one in the neck. I find that those are important to include and shouldn't have been a mistake, and I don't think that his excuse in regards to a misunderstanding would be something that the court should take into consideration. Thus, they should find his testimony to be inconsistent. It has been 8 years since he's left El Salvador, although he still has family there. His father currently lives there. There has not been any indication that the gang has been concerned with his whereabouts since he's left. Thus, I believe that his claim for withholding or removal under CAT should be denied. That's all, Your Honor. Thank you.
It is my opinion that the respondent has suffered persecution in El Salvador. The respondent has testified to multiple violent incidents directed at him by the former chief of his gang and the individuals believed by the respondent to be acting at the behest of the former chief of his gang. The remaining issue for the court is whether the respondent has demonstrated a nexus to an enumerated ground for this persecution. The respondent has claimed in his written application for relief, prepared with the assistance of counsel, that he fears persecution based on the political opinion and on his membership in a particular social group. See Form I-589, Exhibit 9A herein. The respondent has at no time articulated a political opinion which would appear to be the motivation for the violent incidents directed against him. The respondent has merely indicated that his former gang chief of those acting at his behest were seeking to persecute or injure the respondent as a consequence of the respondent leaving the gang without permission. The court finds no reason, in fact or in law, to find that this is an articulation of a political opinion by the respondent, expressed or imputed. Accordingly, the court finds that the respondent's claim of political opinion as the nexus for his persecution is without merit. The respondent also alleges, through counsel, that he is a member of a particular social group defined by the respondent as former members of Mara 18 and El Salvador who have renounced their gang membership. See respondent's brief at page 17. The respondent has unequivocally testified to being an active member of the Mara 18 gang in El Salvador for at least 4 to 6 months. He has testified to being involved in robberies of individuals at least 3 to 5 times and being involved in armed robberies of banks as a driver on at least 2 to 3 occasions. Although the respondent has clearly indicated that he wishes to renounce his gang membership, he cannot disassociate himself from the volitional activities with which he was involved as a member of the Mara 18 gang. In this regard, the court notes that the respondent was not coerced into joining the Mara 18 gang. He has clearly testified that he joined the gang of his own volition based on the promise of an easy life and more things. The Board of Immigration Appeals has previously held that membership in a criminal gang cannot constitute a particular social group for purposes of relief under the INA. See matter of EAG. The board has adopted this rule based on a decision of the Ninth Circuit Court of Appeals, the circuit in which this case arises, which has similarly held that an alien's membership in a violent criminal gang cannot constitute membership in a particular social group. See Artiega v. Mukasey. The respondent seeks to mitigate the effect of this case law on his situation by essentially claiming rehabilitation since his flight from El Salvador in 2001. The respondent has empathetically sought to renounce his activities with the gang as having been engendered by the partially beneficent activities he undertook while under the regime of the gang leader Carlos. Notwithstanding this claim, the fact remains that the respondent was a member of one of the most notorious gangs in Central America, the Mara 18, and that he was involved in multiple armed robbery incidents. The court recognizes the background materials presented by the respondent, which indicate that the El Salvadorian gangs may have multiple motivations and modus operandi in their particular groups. See generally. Background materials attached to Group Exhibit 6. However, the fact remains that neither the Board of Immigration Appeals nor the Ninth Circuit Court of Appeals, the circuit in which this case arises, have recognized rehabilitated members of gangs as a particular social group. Accordingly, the court finds that although the respondent has been subjected to persecution in El Salvador, that he has failed to demonstrate a nexus to a protected ground which would qualify him for relief under the INA. Accordingly, the request for withholding of removal pursuant to INA must and will be denied. Although previously noted by the court that the respondent is not eligible to qualify for humanitarian asylum in view of the pretermission of his asylum claim, the court finds in the alternative that even were the respondent eligible to qualify for humanitarian asylum, that he has failed to demonstrate a case deserving of humanitarian asylum. The Ninth Circuit Court of Appeal has recognized various situations where humanizing asylum is warranted. See generally Belshita v. Ashcroft, Celia v. Mukasey. However, the fact patterns in those cases were far more compelling than in this instant case, where the respondent's past persecution has been limited to having been shot in the leg and involved in a fight in the billiard hall. Accordingly, even if the court were to recognize the respondent's eligibility to apply for humanitarian asylum, it would find that he has failed to state a claim worthy thereof. The respondent has also sought withholding of removal pursuant to Article 3 of the UN Torture Convention. The respondent has testified that he fears that he could be arrested by the police and that he would be subject to reprisals from his former gang should he be compelled to return to El Salvador. The respondent has failed to demonstrate that the police have been searching for the respondent or that he has been charged with any crimes in El Salvador. Accordingly, the court cannot determine if the respondent would be subject to arrest in that country by the authorities should he be compelled to return to that country. Furthermore, the respondent has suggested in his written application for relief that if he is located by his former gang, that he could be subject to various brutal forms of treatment, including having a tire placed on him, being filled with gasoline. However, the respondent has made no reference to any of this during the course of his testimony and has indicated that he believes that he would be killed by his former gang members should he be returned to El Salvador. Background materials presented by the respondent contain little of any information concerning the retreatment of former gang members, such as the respondent, upon their return to El Salvador beyond being killed. Accordingly, the court finds that the respondent has failed to demonstrate by any standard that he would be subjected to torture should he be compelled to return to El Salvador. Accordingly, the request for relief pursuant to the article of the UN Torture Convention will be denied.
It's gonna take a lot to drag me away.